So this video is all about the independent administration of estates in Louisiana. Hey everybody, I'm Paul Rabelais. I'm an estate planning attorney throughout South Louisiana, here today to talk about what's required for a succession representative to be either an independent executor when a will exists or an independent administrator when a will doesn't exist in a Louisiana succession. So somebody dies, they had some assets in their name, that estate has to be administered while this court process is going on. If that succession representative can be classified as independent, then it's easier to get things done. There's less judicial or court supervision. Things tend to go a little faster and without so much, bureaucracy and paperwork. So this is what's required for a succession representative to be independent. All right, so if the person died, I had to go to the board for this one because this one's kind of complicated. If the person died, had a will, the most common way an executor gets confirmed as an independent executor is if the will provides for it. The will might say something like, I authorize my executor to be an independent executor. That takes care of it. Now, if either the will names an executor but they don't mention anything about independent, which every will before 2001 is like that, or if the will doesn't even name an executor, and we see that sometimes when people do their own, they handwrite it and they just don't appoint someone, then either all of the general or universal legatees can agree to allow the executor to be independent. What is a general and universal legacy? Well, it's a legatee. It's anybody who's not a particular legatee. A particular legatee is, I leave $5,000 to X, and I leave everything else that I own when I die to these three people. Well, X is a particular legatee. They don't have to be involved in this decision, but the three others who were left the balance of everything else would be required to participate in this. If a trust is named in the will, then the trustee of that trust can participate in these decisions. Okay, so if a person died without a will, then our rules are for the administrator to be independent. All of the intestate successors may collectively designate a qualified person as the independent administrator. So dad died, he wasn't married at the time that he died, he had 4 children. Our Louisiana law that applies when dad had no will says everything goes to the 4 children. They are the intestate successors. They can collectively, all of them, agree to that a qualified person, and there's a definition for that, be the independent administrator. Some other factors that are involved: if either there was a will or there wasn't a will and someone was left usufruct, that's a Louisiana term. Others were named naked owners, then there's both the usufructuary and the naked owners, if that consent is required, must participate. There's provisions for what happens if a minor is required to participate. And sometimes successions aren't done for a long time, and one or more of the heirs dies from the time of the original death until they're able to make all of these provisions. So there's more there. Once someone is appointed as an independent executor by a judge, the courthouse issues what's called letters of independent executorship. Or once someone who didn't have a will, their succession begins, and the intestate successors collectively designate an independent administrator, and the judge signs the court orders appointing an independent executor. Then the courthouse issues what's called letters of independent administration. Those letters give notice to banks and third parties and financial institutions and title examiners that succession representative has the authority to act under the independent administration of estates procedure in our Louisiana succession law. So hope that helps. You may want to rewind it and watch it a couple of times if you really want to get down and dirty on what's required. So hope that helps. Have a good day.